Welcome, everyone, to the 2021 Hudson Medal presentation. The Manley O. Hudson Medal, the Society's highest honor, has been awarded since 1959 to a distinguished person of American or other nationality for outstanding contributions to scholarship and achievement in international law. The medal has been conferred on many luminaries in the field, including Rosalind Higgins, Tom Frank, Michael Reisman, Ellie Lauderpacht, John Jackson, Bruno Sima, Peter Truba, and Justice Stephen Breyer. Before presenting the award to this year's recipient, I want to just thank Paul Reichler, Larry Martin, and ASIL Law Firm Leadership Circle partner Foley Hoag LLP for sponsoring this program, their 8th year of continuous sponsorship. And we'll hear from Paul shortly. We'll also hear from our honoree, who engaged in an informal conversation with Professor Laurie Damrosch, a past president of the Society, who will have much to discuss with Bernie as they served as co-editors of the American Journal of International Law together for many years. And now for the medal presentation. Upon the recommendation of the Honors Committee, the Executive Council has selected Professor Bernard H. Oxman to receive this year's medal. Bernie is the Richard A. Hausler Professor of Law at the University of Miami School of Law and has been a global leader in forging, strengthening, and teaching the law of the sea and its application in the peaceful settlement of disputes. The award citation included the following quotation from the letter submitted in support of his nomination, and I quote, "Like Manley Hudson, Bernie has contributed to international law in many roles, as scholar, government legal advisor, and international judge, among other positions. And in all of them, his contribution has been distinguished. As assistant legal advisor in the U.S. Department of State, and as U.S. representative and vice chair of the U.S. delegation to the 3rd UN Conference on the Law of the Sea, he played a major role in the negotiation of the United Nations Convention on the Law of the Sea, and especially in the crafting of its path-breaking dispute settlement procedure. He stands at the top of the field today for more than half a century of contributions to the law of the sea and international dispute settlement. For his monumental contributions to international law as a scholar, judge, and arbitrator, the American Society of International Law is honored to present the 2021 Manley O. Hudson Medal to Bernie Oxman. Bernie, my warmest congratulations to you.
Thank you very much.
It's now my great pleasure to recognize Paul Reichler, who will introduce our Hudson Medal recipient and the discussion to come. Paul chairs the International Litigation and Arbitration Department at Foley Hoag and is a giant in the field. Was a highly regarded and experienced practitioner of public international law, specializing for decades in the representation in interstate and investor disputes. Paul, it's a real pleasure to have you with us today. Welcome, and over to you.
Thank you very much, Catherine. It would be difficult to overstate how happy I am that Bernie Oxman is this year's winner of the Manley Hudson Award, and how privileged we at Foley Hoag feel to be part of this presentation. Of course, we all know of Bernie's immense accomplishments over a truly stellar career. To recall them, we only need to review his CV, which is thicker than the Oxford English Dictionary, and I'm only referring to volume 1 of the Oxman bio. He has truly done it all. Preeminent scholar with a list of publications a mile long, outstanding educator who has brought great distinction to the learning institutions that have been privileged to have him. Judge ad hoc at the ICJ and ITLOS, the only American to ever serve in that capacity in both judicial bodies. Advocate for states before Law of the Sea arbitral tribunals. Legendary government lawyer for the United States, gracing the halls of the State Department and the Legal Advisor's Office, and of course, representative of the United States at the historic 3rd Conference on the Law of the Sea, which produced the Montego Bay convention, to which Bernie made immense contributions and supervised the production of the English version. Who else can claim such a record? But what few, if any of you know, is that Bernie's contribution to the law of the sea long predates the convention. According to confidential records that we were able to uncover in the deep recesses of the Dutch archives, Bernie was actually the principal research assistant to Hugo Grotius, and he ghost wrote large sections of Mare Liberum, Freedom of the Seas. But as we all know about Bernie, he is too modest to claim credit for that treatise or any of the many brilliant accomplishments that actually do fill his CV. What about Bernie the person? If you want to undertake Mission Impossible, go try to find someone who has an unkind word to say about him. You won't succeed, because Bernie is one of the kindest, gentlest, generous spirited, and most decent human beings you will ever meet. He's just a wonderful guy. Everybody loves him. He's even my own wife's favorite American international lawyer. And he's mine too. I was blessed to be his colleague in the Philippines-China arbitration over the South China Sea. You could not conceive of a better colleague. And it was a privilege and a great and unique learning experience to observe Bernie engaging with Rudiger Wolfram, last year's Hudson Award winner, Tom Mensa, Jean-Pierre Cote, and other distinguished experts on the tribunal over interpretation of fundamental provisions of the 1982 convention. I've also had the good fortune to appear before Bernie in his capacity as a judge in Bangladesh, Myanmar, and Mauritius, Maldives. He combines a mastery of the law with an admirable judicial temperament. As a member of a tribunal, he's a consensus seeker and builder. Remarkably, he often manages to co-author a separate opinion with the judge ad hoc appointed by the other party. How can we explain this? Because he is not only a superstar international lawyer, he is a superstar human being. I am very proud to have him as a friend and extremely happy for him today. Congratulations, Bernie. We love you. And now we will turn the proceedings over to Professor Laurie Damrosch, former colleague of Bernie's, who has promised an enlightening and revealing interview with our award winner.
Thanks so much, Paul. This is such a pleasure for me to conduct this interview. Indeed, I have known Bernie for a very long time, first by reputation and then directly. So I joined the Office of the Legal Advisor in September of 1977, and that was just as Bernie was leaving that office to take up his academic post at the University of Miami, and his reputation was already legendary. I didn't have much need in my first years in the office to immerse myself on law of the sea, but he was obviously the go-to person, and everyone in the office was already singing his praises, and I didn't even meet the guy until sometime later. So when did our paths first begin to cross? As I recall it, we were introduced by our shared mentor, Jack Stevenson. This would have been in the mid-1980s in the aftermath of the Nicaragua case. And I had just joined the Columbia Law faculty. Jack reached out to me and invited me to organize an academic study on the International Court of Justice in the aftermath of Nicaragua. And in formulating our list for the very first scholars that we wanted to reach out to, Jack said, "You've got to get Bernie on your team because he knows everything about provisional measures." So this is not a topic on law of the sea. This is a topic on international adjudication. So we brought Bernie into the study of the International Court of Justice at a crossroads, and we'll be talking a little bit later about provisional measures in various international tribunals. That collaboration was such a success that when I then organized another study group for the society, which was with the then Soviet Union, the Soviet Union did not endure as long as our project endured, but Bernie and I got a wonderful trip to Moscow about it. So Paul, I want to compare you anecdote for anecdote about what it's like to be traveling in foreign places with Bernie, because I remember a lot of things about our trip to Moscow, including our visit to the Moscow Conservatory and a few things about the academic pension where they put us up. In any case, we then, by this time, our collaboration was pretty fully fixed. And by the time I was invited to join the board of editors of the American Journal of International Law, he had been on it for quite a few years already. So he welcomed me to, I want to say that fraternity. He became, some years later, the international decisions editor of the American Journal. And toward the end of that period of his career, about, let's see, when is this going to be? This would be the year 2013. We formed a team and we were selected by the board of editors to become the co-editors in chief of the American Journal. So we had 10 years together. We talked at least once a week, maybe more often during that period, and got to know each other pretty well. So against that background and bearing in mind all the highlights that Paul has mentioned to you and a few other highlights that I'm going to dole out along the way, I want to go back to Bernie's earliest days. He was born in New York City. He grew up in Brooklyn. I'm sitting right now in Brooklyn. He studied at Columbia in the 1960s for both college and law school. That happens to be the law school where I've been teaching for a while. So the first question that I want to put to Bernie has to do with his New York years. During your time in Brooklyn or during your time at Columbia, either college or law school, were you already being drawn toward international law? Did you study international law at Columbia Law School? Did any of your professors influence you or encourage you in this direction? Speak.
The answer is yes. First, let me thank you, Laurie, and thank Paul, and thank Catherine for the very, very kind words. I'm not sure that I can recognize the person that you were talking about, but it sounds like someone I would like to meet. My interest in things international actually began as an undergraduate, and one of the things that stood out was that I took a course in nationalism in sub-Saharan Africa as an undergraduate, and that very much piqued my interest in international affairs. I'd barely begun my studies at Columbia Law School when the Cuba Missile Crisis was upon us. As you might imagine, the talk of nuclear annihilation did catch my attention. Subsequently, after completing my first year, I did study international law at Columbia Law School with the legendary Wolfgang Friedman, who was a spectacular teacher. I do recall that he used the Bishop's then famous casebook with monumental notes, all of which I tried to read. And Friedman definitely piqued my interest in international law. Among other things, his lectures included very lively critiques of Myers-McDougall and what came to be known as the Yale School. And that caused me in turn to check out what Matt had to say as well. And that further piqued my interest in international law. During the law school period, my interest in international aspects of the law was not limited to public international law. I also studied the civil law system with Henry DeVries. I was his research assistant. And my job was to work on updating his short book that introduces the French legal system. That book was co-authored with the prominent French scholar René David. The book had gone to press shortly before the adoption of the then new French Fifth Republic Constitution. And so you can imagine that therefore was the principal focus of my work on updating. There were also other inspirations. My encounter with Lou Henkin while I was at Columbia was focused on constitutional law rather than international law. But by the time I was working in the Pentagon after law school, he acquired an enduring influence on me that lasted throughout my career.
Great. Well, I'm glad you gave all the right answers to those questions about your background, including that you mentioned your work as a research assistant in the French language, because Paul has highlighted the role that you played in bringing to completion and to perfection the English language text of the Law of the Sea Convention. But I would venture to suggest that the superlative legal diplomatist needs to know French almost as well as English, and I'm sure that that is true in your case. So, so you graduated from law school and then you found a job. I gather it was with the Navy Judge Advocate General Corps. And I just wonder if you could give us a few words on how you came to apply for the Navy JAG position and how you found your way into the field of international law through that particular route.
Yes, well, when I graduated from law school in 1965, we were in the midst of the Vietnam War, and my graduation not only signaled the award of the degree from Columbia, but it also signaled that my deferral from the draft would come to an end. And my options in that situation were limited. I had heard about the Navy JAG program, and I decided to apply. I was accepted, and in fact, I was commissioned by the Navy just in time to preclude the Army from drafting me, and I had the pleasure, I'm sure Paul would have enjoyed this as well, I had the pleasure of sending them a letter citing the statute that prohibited them from drafting members of the armed forces. As my training in Newport was drawing to a close, two very fateful events occurred that really do presage the future course of my careers. We can probably use the plural. I received orders to report to the Office of the Judge Advocate General of the Navy in Washington. But at the same time, the Naval Justice School, where I was studying, invited me to remain there and to teach. And I had to make a decision. By this point, I had become quite interested in questions of international law, but I was told that it was very unlikely that the Judge Advocate General's office would assign a junior officer fresh out of Naval Justice School to the International Law Division of the JAG office in Washington. I nevertheless decided to give it a try. And so I called someone at the personnel office in Washington. I explained to them that I had orders to come to Washington from the JAG office, but that I was also invited to stay and teach, and that I really wanted to know whether they would be assigning me to the International Law Division, because if they were, I would be inclined to come to Washington. If not, I would be inclined to stay in Newport and teach. And the individual said that he would have to check the file. And the real question was whether I had reached someone who understood why I was really making the call. And I stood in the phone booth. I can remember this. Most of you watching now don't know what phone booths are. It was a coin-operated telephone. It was freezing in my home phone booth in Newport, Rhode Island, in February. And I'm putting quarters, which was a lot of money for a phone booth at that time, in while I wait to get a response. And indeed, I was not certain that my supply of quarters would in fact last long enough. But sure enough, after a substantial period of time, the individual in the personnel office came back, said he had my file in front of him, and the file said that I was going to the International Law Division of the Office of the Judge Advocate General of the Navy. And so I went to Washington. I showed up in that office. My first job, I remember, was to draft documents leasing a destroyer to Brazil. But shortly thereafter, the Soviet Union delivered a note, diplomatic note to the United States and a number of other countries, inquiring as to whether there would be interest in convening another global conference on the law of the sea for the specific purpose of agreeing on 12 nautical miles as the maximum permissible breadth of the territorial sea. The Secretary of State, as you can imagine, wished to elicit the reaction of interested departments in the government, which of course would include the Department of Defense, and therefore sent a note with an inquiry over to the Secretary of Defense. For those of you who have worked in large bureaucracies, you know what happens next, and that is that the inquiry went from the Secretary of Defense to the service secretaries, including in particular the Secretary of the Navy and the Chief of Naval Operations, and it went from them to the Judge Advocate General, and it went from the Judge Advocate General to the head of the International Law Division in the Navy JAG office, and proceeded on its way down until it reached the absolute bottom from which it had no further to go, which was my death. And it became my job to organize what became a huge multi-month study within the Pentagon of whether we were prepared to move away from the position of the 3-mile territorial sea that had been first announced for the United States by Thomas Jefferson. This was a very daunting task. I was very fortunate to be able to have significant advice and guidance from Admiral Wilfred Hearn and Admiral Joseph Devitt during that period in order to navigate my way through the Pentagon without having my head chopped off. As some of you may know, the end of that process was that the Department of Defense informed the Department of State that it was prepared to support further discussion with the Soviet Union on the matter on condition that freedom of transit for all ships and aircraft through straits overlapped on the territorial sea would be expressly preserved. And that's the beginning, as it were.
That's the beginning. That's the beginning. So then we want to move to the next step, which is that I gather from your CV that after a few years at the Pentagon, or maybe shorter, I don't have the date right in front of me, you moved across the river from the Pentagon over to the Department of State and into the Office of the Legal Advisor. So how did you move from the International Law Division in the Pentagon to the Law of the Sea portfolio at State? And who were the main influences on you in your time at State?
It was a surprise. In the course of my Navy service, and I'm very proud of this, I received a Navy Commendation Medal. And when I read the citation, it did seem to me that the real purpose of awarding the medal was for valor in battle against the State Department. Seriously, though, not all of my contacts with the Department of State involved disagreements between my client and the Department of State. While I was in the Navy, I was very privileged to have the opportunity to be of some assistance to Steve Schwabel, who at that time had been asked by the State Department to handle the very difficult and persistent issue of claims by Micronesians against Japan and others, largely for injuries suffered in the course of World War II, in part as a result of the unlawful arming of the islands of Micronesia in violation of the mandate. That was the beginning of an enduring and immensely rewarding and influential relationship, so far as I'm concerned, with Steve Schrebel, who was a towering figure in international law and whose wise counsel I, of course, continue to rely to this day. That said, like many Columbia Law graduates at the time, I thought that I would be going to a Wall Street law firm. Indeed, at the end of my second year law school, there had been some offers of summer jobs at Wall Street firms, and I consulted Herbert Wexler at the time, who told me to decline all of the requests and travel abroad for the summer because this would be my last school long vacation opportunity to do so, and that what I should do is expose myself to foreign languages and cultures on the assumption that I will then have ample opportunity to expose myself to law. And that's what I thought I would be doing. And so I was really quite surprised when in the fall of 1968, as my active duty commitment in the Navy was coming to an end, I received a telephone call from the then legal advisor of the Department of State, Leonard Meeker, who inquired whether I would be interested in coming to work in the legal advisor's office. After some hesitation on my part, I accepted that offer. The Johnson administration was coming to an end soon thereafter. And sometime after that, John Stevenson, who you referred to already, Laurie, became the new legal advisor of the Department of State. And soon thereafter, he assumed principal responsibility for the law of the sea negotiations within the Department of State and eventually within the executive branch as a whole. And I worked directly with Jeff Stevenson in that capacity. It was an extraordinary privilege from which I learned a great deal, including, to add a moment of levity, I learned never to leave the original document alone with him on his desk. When Congress created a new Bureau of Oceans, Environment, and Science within the Department of State, Stevenson sought White House approval to name me as the assistant legal advisor responsible for providing legal advice both to the new Bureau and to the interagency process working on the law of the sea. And I want to add that it was also Stevenson who created the position in the legal advisor's office of counselor on international law and who persuaded Louis Sohn to be the first person to hold that position. And Louis Sohn was thus drawn into the law of the sea circle by Stevenson, and I in turn had the opportunity to work closely with Louis as well. As you can see from this pattern, I have been extremely fortunate in the people I have had the opportunity to work with in the course of my career. And I definitely want to make clear that I include within that both you, Laurie, and Paul, who have been fascinating colleagues to work closely with.
Thanks. Well, we now want to turn to that period in which the Law of the Sea conference was active, the period from 1973 to 1982, when you were working initially with Stevenson and then later with Elliot Richardson in the US delegation. I gather you were the vice chair of that delegation, and as Paul has already mentioned, the chair of its English language drafting committee. So from that period of roughly 9 years or so, are there any reminiscences or anecdotes that you would like to convey about those experiences?
Well, as you know, Laurie, I've had ample opportunity to address the substance of the negotiations in my writings, and mostly in the American Journal of International Law, but elsewhere as well. And in fact, my most vivid memories, this is a wonderful question, are of the extraordinary people, both Americans and foreigners, with whom it was my privilege to work closely. There are far too many to mention by name, and that speaks volumes about my very, very good. You mentioned Richardson, the opportunity to spend years working directly. The towering figure, really, of unwavering character like Elliot Richardson simply cannot be duplicated. One of Richardson's observations about the law of the sea negotiations was that influence in a complex multilateral negotiation is not exclusively contingent on the influence of the country that is being represented, but may also depend as well on the quality of the representative. And this is extremely important insight. I could cite many, many examples. One clearly good example in the law of the sea negotiations was my good friend Tommy Koh of Singapore, whose uncommon ability propelled him to the presidency of the conference itself in its climactic years. The other recollection is the challenge of coordinating a huge delegation like that which was sent by the United States to the law of the sea negotiations over a period of many years. Our delegation included not only representatives of a very large number of federal government agencies, but members of Congress and congressional staff, as well as public members who represented a variety of different interests, a variety of different non-governmental organizations, and even religious organizations. I do remember that a Wall Street Journal reporter, who was not necessarily favorably disposed to these negotiations, once asked me about the ample size of the US delegation at the first substantive session of the Law of the Sea Conference, which took place in Caracas. And I do recall that I replied that in a spirit of participatory democracy, we brought our country with us. I do remember, for example, that Jack Stevenson once reported to me on the conversations he had with the then chair of the Group of 77, the group of developing countries, who was complaining to Jack about the difficulty he had of coordinating all of these different positions of these different countries. And Jack, of course, replied and said that it's nothing compared to the challenges that I face in coordinating all of the different interests within the United States that are represented on our delegation. It was not by any stretch of the imagination a simple operation, and the conclusion that there would be a convention adopted that would in fact be widely accepted was not foregone. Shakespeare, it took very, very hard work and a good deal of imagination on the part of many.
Great.
Responses.
Okay, I want to move to the phase of your career that's the scholarly career, both your contributions already mentioned to the American Journal over many years through the series of articles explaining the stage of the negotiations of the Law of the Sea Convention and conveying what it was all about, and for this extraordinary series of articles from 1974 into the 1980s, you were awarded the American Journal's Francis Dayak Prize for the best contribution by a younger author. And then moving ahead, a couple decades, I guess, when there came to be an inflection point for the Law of the Sea and the preparation of the modification agreement, the implementing agreement for Part 11, that basically resolved all of the objections or concerns that the Reagan administration had raised about the 1982 convention. I think your 1994 article laying all of those concerns to rest really holds up beautifully as the best piece for explaining to anyone why those older objections to the initial treaty have been solved in the modification agreement. And I continue to recommend that to all of my students. You joined the University of Miami faculty, as we've heard, and in 2007, when you were designated to the Richard Hausler Chair, I had the privilege of coming down to the University of Miami for a symposium event on what was then your most recent article on the law of the sea. It was your centennial essay contributed to the American Journal called "The Territorial Temptation, a Siren Song at Sea." And we had a lot of fun thinking about temptations and sirens and Homer and Ulysses and all sorts of classical images. And I would really recommend that article to anyone who's looking for a very readable overview of a century of scholarship and practice on law of the sea, and also why we should resist temptation. So I would give you the opportunity, Bernie, to explain why we should resist temptation, but I want to move ahead to what I think is going to be the most interesting feature of your career to many who are listening today. And that has to do, first, well, with your scholarship on peaceful settlement of disputes, which is not limited to peaceful settlement of disputes on law of the sea. It's really a wide-ranging scholarship on peaceful settlement of disputes. And then your role that Paul Reichler has mentioned as counsel, arbitrator, and judge ad hoc of the International Tribunal for the Law of the Sea and of the International Court of Justice. And I was going to mention the same thing that Paul has already mentioned, but I'll elaborate it a little bit. So the Law of the Sea Convention sets up these three pillars of dispute settlement, arbitration, the International Tribunal for the Law of the Sea, and the International Court of Justice. You have served as an adjudicator in all of those roles, in an arbitral setting, as a judge ad hoc of the International Tribunal for the Law of the Sea, and as a judge ad hoc for the International Court of Justice. And you've also served as counsel in arbitrations and at the ICJ. And as Paul mentioned, I believe that we are both correct that you are the only American to have served as a judge ad hoc for both the International Tribunal for the Law of the Sea and the International Court of Justice. So Catherine quoted a passage or two from a letter that several of us submitted to nominate you for this Hudson Medal, and she didn't single out the aspect of the letter that refers to really your unique role as a judge ad hoc, both at the International Tribunal for the Law of the Sea and subsequently at the International Court of Justice. Our letter put it that you really reinvented the role. Paul alluded to this. Paul mentioned how by joining together with another judge ad hoc and uniting in a single joint opinion of two judges ad hoc, you could do something totally different from two judges ad hoc who would be reciting the positions of the parties who appointed them. And I'd also want to mention that for the ICJ case on which you served as a judge ad hoc, the judgment of the court in that case was absolutely unanimous. No separate or dissenting judges by anybody, not by either of the judges ad hoc. And I think that's really a tribute and a testament to your consensus building qualities. So I would be delighted to have your reflections on what it's like to sit as a judge ad hoc. I know you can't tell us anything about confidential deliberations, but maybe you can tell us about the size and shape of the table, or maybe you can tell us about the lunchroom, or maybe you can tell us about any aspects of your experiences that would be enlightening for our student audiences or for any of us who are interested in the roles of these tribunals in the peaceful settlement of disputes.
Wow. Well, on the last point, architects, of course, make this point that physical arrangements will make a difference. At the time that I served, the International Court of Justice had a modern, relatively new, circular table in its deliberation room so that most of us could see everyone else. But on the other hand, it was in the splendid Great Hall of Justice, which nevertheless didn't work all that well in terms of the modern facilities that are used by counsel to better explain the cases to the judges, and I'm not sure that the improvements that they've made in this respect since then at least satisfy my aesthetic attitudes, but that's neither here nor there. The situation in Edlos was exactly the opposite, as it were. The courtroom is absolutely splendid. It is large. It is circular. Wherever you sit, you're looking directly at counsel. You have all of the electronic facilities immediately at your disposal. And in fairness, of course, the Edlos facilities are built in a period when people were already interested in using electronics. The Great Hall of Justice in the Peace Palace was built many, many years before that. On the other hand, the deliberation room had a very long table. And the deliberation room, you have the president and the registrar sitting at the head of the table, so they could in fact see, which is very important, everybody else. And you were then seated by seniority. The effect of that is that the judge or judges, in the case in which I sat, ad hoc are sitting at the other end of the table, either across from or next to each other. It didn't much matter. We were, of course, also the only others in the room who actually had a view of everybody. And there was a tendency that afforded you an opportunity. It was not the only opportunity, but it afforded you an opportunity to get to know each other. In the land reclamation case, which was at the provisional measures stage, the other judge ad hoc was Kamal Hussein. We had not had the opportunity to work together before, and we did then. Now, it didn't occur to either one of us that we would be breaking precedent, as it were, by ending this with a joint declaration. We did both support the judgment, the provisional measures order of the tribunal, and one about which I wish more could be written, given the fact that this was an interesting environmental case. But we faced something of a technical issue, and it's a nice illustration of how something like this can happen. The International Court of Justice had a practice in its provisional measures decisions of including a sentence that said that this was without prejudice to the merits or to jurisdiction. And that formula sentence appears routinely in International Court of Justice decisions. The difficulty here is that the jurisdiction of the International Tribunal for the Law of the Sea in the case was limited to provisional measures pending the constitution of an arbitral tribunal. The Law of the Sea Tribunal did not have jurisdiction over the merits and over questions of jurisdiction on the merits, but the two ad hoc judges had already been appointed to the arbitral tribunal that would sit on the case in the merits. And therefore, we felt at least that there was an argument that we should follow the precedent of the International Court of Justice and indicate, at least for ourselves, that this was without prejudice to any question of jurisdiction or the merits that would be scheduled to come before us as members of the arbitral tribunal. And that was, in fact, the genesis of the idea that we might say something together that was relevant to our future role in the case, but was not directly relevant to the role of the tribunal. And that emerged into a joint declaration in which we, in fact, went on and said some other things that I've always hoped proved helpful. You've had, I think it's fair to say, you can read it for yourselves, that you have both ad hoc judges having nice things to say about each of the parties. And one hopes that in some way contributed to cooperative implementation of the very creative provisional measures order in that case. And the provisional measures order in that case, in fact, once it led to the studies and report that were required by the order, brought the parties to a situation in which they could settle the case, which is a very desirable underlying result. Similarly, in my service on the International Court of Justice in the Black Sea case, neither I, and I suspect perhaps no one else, that I don't know, imagined that we were going to end the case with a unanimous judgment and no separate opinions. There's no way to know at the outset, and you simply approach the case with an open mind. It is clear that one of the interesting aspects of maritime delimitation cases is that the underlying standards for maritime delimitation, both in the text of the Law of the Sea Convention and as articulated by the International Court of Justice and other tribunals in their opinions, is a relatively flexible one. There is not only one boundary that can be said to satisfy the legal requirements. There are a range of possibilities. Judge Weibel, in one of his opinions, makes this point very elegant language. And therefore, you could expect one of two things to happen. One is that you could have a situation, which would be rather chaotic, in which you had 15 judges with 15 opinions supporting 15 boundaries, all of which could rationally be said to satisfy the criteria. Or the other is that there would be a wide range of possibilities for assembling a group that felt that the outcome satisfied the legal criteria. Those legal criteria, in the words of the Law of the Sea Convention, have to include an equitable result and come together, as did happen in the Black Sea case. And the Black Sea case also has to be seen in context as the culmination of a reaction of both the International Court of Justice and other tribunals to initial articulations of this process in earlier cases. And of course, one of the many functions of judges in cases is to develop some concern to the question of precisely how the law on the topic should be articulated and developed for the benefit not only of future tribunals, but for the benefit of governments that will try and implement that law in other situations. And these are many things that one would think about. Now, it is true, therefore, that the end result in the Black Sea case was not something that I believe Chateau Rosen is the one who said that had really happened before, and that is a final judgment on the merits with two ad hoc judges on the court, right? And no separate opinions whatsoever. And again, that, like the joint declaration in the land reclamation case, and there were subsequent joint declarations, is, I think, has to be attributed in many ways to the extraordinary individuals who are also serving as judges ad hoc in the cases in which I was appointed, and indeed in cases in which I'm serving now. That were it not for the character, imagination, abilities of these individuals, I'm not sure that any of these changes would have occurred. And obviously, I do think that they are for the better. I didn't set out to reform the system. But when I was appointed a judge ad hoc, I obviously tried to do some reading and research that included S.C. Schreibel's article on the subject. And I pretty much decided that, like Manley Hudson, I did not agree with Hirsch Lauderpacht's criticisms of the institution of judges of the nationality of the parties or ad hoc judges. But I did agree with Lauderpacht that the point of departure and point of analysis is the solemn declaration. And I do want to emphasize this. Article 20 of the RCJ statute requires every judge, including the ad hoc judges, to make a solemn declaration, exercise his or her powers impartially and conscientiously. And Article 11 of the IFLAS statute says exactly the same thing. You don't have that requirement with respect to arbitration under the Law of the Sea Convention, or typically, but I would point out that the qualifications for being on the list of Annex 7 arbitrators under the Law of the Sea Convention is that a person must enjoy the highest reputation for fairness, competence, and integrity. And I think if you start out there, then you have to reach the conclusion that the kinds of sharp distinctions that may have been drawn between ad hoc judges and other judges are not necessarily the only way in which to interpret their role. You can make an argument that the ad hoc judge should try to ensure that the arguments made by the appointing party have been fully and fairly heard. I have to say, in my very limited experience, I've only served on a few cases, that this is rarely a difficult or onerous task. There's very widespread agreement with the underlying premise that each of the parties arguments should be fully and fairly considered, right? And there's in fact very widespread agreement that the judgment itself has to make clear that that this has been done. And while there are others who have a different view, I remain personally to be convinced that an individual opinion by an ad hoc judge favorable to the appointing party adds significant reassurance in regard to this question. That said, of course, every case has to be approached with an open mind, both on the merits and in terms of the conception of how one envisages one's role in the process, and you can't come in with a priori notions of precisely how that is going to develop. Indeed, law professors, or at least this law professor, have to remember that the process of being a law professor is very different from the process of judging. A lot of people have written on it. It's very important that it be borne in mind.
This law professor has the eye on the clock here, and I'm afraid we're going to be cut off at 1:30. And before that happens, I want to say a few things. First of all, there's a separate link to continue the conversation segment, so that Bernie will be available starting from the close of this program for about half an hour, as will I, for those of you who would like to pose questions directly to him. In this Zoom format, we didn't receive questions as could have possibly been accommodated, and we're quite short on time. But before we go, I do have a couple of final remarks. In the letter that a whole lot of us joined, every living president of the American Society of International Law and all but one of the living Hudson medalists. We couldn't track down one stray one, but we got almost all of them to endorse our honoree today as not only deserving of the honor, but really the most deserving, and on so many different dimensions of being a scholar, of being a practitioner, of being an arbitrator, of being a judge. And on this last point, the point Bernie has been speaking to about the role of the judge ad hoc, I think there's a very revealing comment or set of comments in our own American Society of International Law Proceedings when Judge Rosalind Higgins, who has spoken at a number of our annual meetings and spoke in 2001, was speaking about the role of the judge ad hoc in general, and then the particularly stellar examples. And she started out by saying that the role is as a security blanket to states in front of the court. Okay, so that's the generic. But then she says there are two sorts of ad hoc judges who are really especially useful for the court. And one is when you have judges, I'm quoting here from Judge Higgins, when you have judges who are really and truly experts in a particular field. For example, in her last case, Judge Higgins' last case as president, Romania versus Ukraine, the court got a tremendous bonus from having Bernie Oxman and Jean-Pierre Cote. They both knew so much about the subject, and you could not have told in the discussions and in the help they gave us who had been appointed by which party. I think that really so well illustrates the point that Bernie has just been mentioning about how the judges ad hoc, like all members of the tribunal, take that solemn declaration very seriously and are doing the utmost in fairness and impartiality and independence. So I would just end up by quoting the last sentence of our letter, that we, the nominators, believe that Bernard Oxman is among the most distinguished international lawyers of his generation, and that the society would honor itself, as it has in fact done, in awarding him the Manley O. Hudson Medal. So thank you so much for the honor of being able to interview today, and I turn the floor back over to Catherine Amirvar for concluding remarks.
Thank you so much, Lori. Thank you so much, Bernie. I think the stories that we heard today are a real testament, and I think bring to life why this is such a well-deserved recognition. And frankly, Bernie, why you are so beloved by this community. So just a congratulations again to everyone. Thank you so much for joining us. Please do join us at 3 p.m. Eastern for the presentation of the Butcher Medal to the Honorable Louise Arbour. In the meantime, as Lori mentioned, there is a button that says continue the conversation so that you can join us and chat and congratulate Bernie directly. So thank you everyone for this magnificent program, and congratulations again. We'll see you soon.
Are you going to continue the conversation here? There was a class here after. I thought it was only until 1:30. They only mentioned an hour. But it's okay. We can probably hold them off for 10 minutes.
I think the class is
Can we confirm we're off stage? Thank you. That was just terrific. Boy, did I enjoy hearing those stories. I think now, Bernie, in the chat, you'll see there is the continue the conversation link. If you want to go ahead and click, we will see you in that room.
I'm at your disposal as to how we
Hi, welcome. Thank you all for joining us for what promises to be a thought-provoking debate about parallel proceedings in investment arbitration. First and foremost, a huge thank you to ASIL and in particular, the mastermind behind this session, Ben Love, for making it possible. Thank you, Ben. Now, my name is Lindsay Gastrell, and I'm honored to be your moderator for this session. In a moment, I will get to introducing our extraordinary speakers and tell you a bit more about the motion that is up for debate. But first, just a few quick words about how this unique session will work. So it's a debate, and we not only have two superbly qualified debaters, but we also have an esteemed 3-member tribunal that will be hearing the arguments. And so we'll begin the debate with a 10-minute opening statement from each side, followed by 10 minutes of tribunal questions, and then a 5-minute rebuttal from each side. And at that point, the tribunal will discuss the issues, in front of the audience and render its decision. But the real judge here today is you, the audience. After I introduce the motion, you'll have an opportunity to vote for or against it. And I'm going to hold on to those results. You'll have a second opportunity to vote after hearing from the debaters. And so you can see by comparing the results of the two votes, we'll be able to see which of them was able to change the most minds. Now, your Q&A box, I'm sure you know how to use it. Please do, especially if you have questions for the debaters. Please share them, and the tribunal can pick up on those during the question period. So let's get to it. The motion that you'll be asked to vote on in a moment is yes or no to this statement. Parallel proceedings in investment arbitration are abusive and should be banned. So just a tiny bit of background. Investment treaties, as we know, grant foreign investors certain substantive rights as well as direct remedies for enforcing those rights. And most notably, that's access to international arbitration. But those rights are not granted to the investor in a vacuum. They may be in addition to domestic law rights, contractual rights, and when a foreign investment is made through a multi-level corporate structure, as is often the case, different entities in the chain may have rights under different investment treaties. So what is the result? Well, when the state adopts a measure that interferes with the investment, the investor now has many different avenues through which to seek redress. And, it may choose one, but it may choose more than one. And so you can have a typical example of, a domestic subsidiary brings a domestic lawsuit, maybe also a contractual claim against state entities. And then you could have a direct parent that brings a claim against the state under one treaty, and perhaps an indirect shareholder of a different nationality that brings a claim under a different treaty. So you can see now the investor has just made use of the various rights afforded to it and has increased its chances of prevailing in at least one of the fora, which is great, right? Well, not if you're a state and you're forced to defend against multiple claims arising out of the same set of facts, racking up legal fees, being dragged from hearing to hearing. From this perspective, parallel proceedings are not only chaotic, but they distort the balance of rights. What could be more prejudicial and abusive, right? Not to mention that parallel proceedings threaten the legitimacy of the entire investor-state settlement system. So what is a tribunal to do? And perhaps more importantly, the question is, what can a tribunal do? Isn't the investor's right to bring a claim, which is expressly set out in the treaty, the end of the story, right? Arbitrators shouldn't be permitted to throw out a valid claim just because they don't like it. Or has the claimant sort of forfeited that right by exercising it in an abusive way? Should the tribunal find the claims to be an abusive process and therefore inadmissible, as we saw in Orskam v. Algeria? So these are the issues. These are the complexities and conundrums associated with parallel proceedings are popping up more and more in the cases, and they've been identified as an area of concern at UNCITRAL Working Group 3, which is focused on the reform of investor-state dispute settlement. But more importantly, for present purposes, these issues are on the table for debate today. And so now it's over to you, the audience, to vote on the motion. And can I ask Brandon, could you pull up our first poll, please? And the members of the audience, for this purpose, I think you'll be able to click on the Q&A box, I'm told, and you will see the poll. And I'll just give you a second there. What is your view coming in off the street? Yes or no, parallel proceedings in investment arbitration are abusive and should be banned. And like I said, I don't see that poll, but I assume that it's available there for you. And like I said, we'll hold on to these results and we will reveal them after you've had a second chance to vote, having heard from the debaters. So, arguing in support of the motion, we have Mr. Sam Wordsworth QC, a member of Essex Court Chambers. Sam is an expert in public international law, having literally written the book, and actually 2 books. He is one of the co-authors of Halsbury's International Law and Foreign Relations and the forthcoming Oppenheim's International Law. Now, the list of cases in which Sam has acted as counsel before the ICJ is much too long to recite here, but he's also regularly instructed in investment treaty arbitrations and teaches on the subject as a visiting professor at King's College London. And opposing the motion, we have Professor Jan Paulsen, a name that is no doubt familiar to you. As counsel, arbitrator, and scholar, Jan has profoundly influenced the field of arbitration. He led the international arbitration practice at Freshfields before forming 3 Crowns, and he's recently retired to practice independently. If you want to know the great cases in recent arbitration history, you can just use Jan's CV as a guide, and his many impactful publications include most recently the book, The Unruly Notion of Abusive Rights. Turning now to our esteemed panel of arbitrators, we have Ms. Maryam Godsaritsa. She is the head of the arbitration department of the Ministry of Justice in Georgia. And in this role, she represents Georgia in investment treaty arbitrations, as well as in UNCITRAL Working Group 3. So we're privileged to be able to draw on her extensive practical experience. And sitting with Maryam is Ms. Colleen Mawad. She's a partner at Chaffetz Lindsay here where I am in New York. She has 20 years of experience representing clients in both commercial and investment treaty arbitration, and she is recognized by, trust me, there's countless rankings, including as a global thought leader in arbitration. And she's also the vice chair of the ICC Commission on Arbitration and ADR. Finally, chairing the tribunal is Professor Pierre Mayer, another household name in the field of arbitration. He is one of those great renowned arbitrators who often presides investment treaty tribunals, as he's doing here for us today. And he also sits in large, complex commercial cases. He's a member of the International Law Institute and has taught for decades at Paris 1, the Sorbonne, where he is an emeritus professor. Just a final note before I turn it over to the speakers. The views that are expressed here today are for the sole purpose of this event, and they correspond to assigned roles. So please, they shouldn't be attributed to any of the individual speakers. That is plenty from me. I will turn it over now to our president, Professor Mayer.
Thank you, Lindsay. Thank you for this introduction, which sets the scene and describes the problems. We'll have the solutions now. We'll have the debates. And first, Mr. Wordsworth, you have the floor for the positive answer to the motion. Please.
Thank you very much, Mr. President. Sometime around 480 BCE, Heraclitus observed that you can't step into the same river twice. And indeed, applying a strict identity test, it's true, you can't. When you put your foot back in for the second time, the water has flowed on, and the river is not quite the same. Sometime around October 2003, which in terms of the development of investment treaty arbitration is not materially more recent, the two tribunals in the CME and Lauder cases showed that they were able to agree on one thing, that is, the application of a similarly strict approach to identity. Hence, there was no abuse in two claimants in the same ownership chain, bringing virtually identical claims under BITs that, however substantially similar, were correctly to be seen as separate. Leaving to one side the inconvenient fact that the Czech Republic had not assisted its position by a refusal to consolidate, most commentators considered that outcome to be deeply problematic. Intuitively, investors, like claimants more generally, must be bound by the rule that you can't take two bites out of the same cherry. And here, the two bites resulted in one successful defense by the Czech Republic and one bill for $260 million. At the same time, however, the difficulty was and is that the no two bites rule ultimately derives from the laws of physics, while the legal manifestations of the rule, most obviously the rules on lis alibi pendens and res judicata, have often been understood as requiring satisfaction of a strict triple identity test. But in the years since CME and Lauder, an intense spotlight has been shone on the potential for abuse, both in investment arbitration and more broadly, with the ICJ recognizing recently in Equatorial Guinea and France that in exceptional circumstances, a claim based on a valid title of jurisdiction can be rejected on the ground of abuse of process. And I read Professor Paulson's important new monograph on abuse of rights as being to the same effect. So even absent a specific rule in an investment treaty, a tribunal applying international law today has a much more well-established basis for declining to hear a parallel claim if there is an abuse of process. And it's not just that there is a rule apt to ban parallel proceedings, it is a rule that has been applied and with persuasive force by the notably distinguished tribunals in Orascom and Ampel. The correct appreciation now is that parallel proceedings not so much should be, but are abusive and hence banned. And the two questions for today are really what is meant by parallel and what can be meant by banned. Of course, these are difficult questions for a 10-minute slot, but in brief terms, it would be rare for there to be sufficient and therefore abusive parallelism between claims that stem from separate legal orders, that is, international law and domestic law, most obviously where a claimant seeks to bring a treaty claim and a contract claim before another forum. Landmark cases like Vivendi 1 have demonstrated how such claims are legally and materially separate, despite whatever overlaps there may be on the facts. And there are multiple other rules that may be applicable to regulate and manage overlapping treaty and contract claims. Similarly, parallel claims concerning different, though related areas of international law appear unlikely to be abusive. For example, where a claim brought under a human rights treaty is accompanied by a claim under a BIT, as in the UCOS cases. As the ICJ has noted in Ukraine and Russia and various other recent cases, the fact that a dispute before it forms part of a complex situation that includes various matters and various treaties cannot lead the court to decline to resolve that dispute, provided that the parties have recognized its jurisdiction to do so and the conditions for the exercise of jurisdiction are met. So why would that approach not apply where legally separate entities in a corporate chain bring claims under two separate investment treaties? Why should that be seen as parallel and abusive? One answer, as follows from the Orascom Award, lies in the very purpose of investment treaties, which, as the tribunal aptly explained, exist to promote the economic development of the host state and to protect the investments made by foreigners that are expected to contribute to such development. And it follows that if the protection is sought at one level of the vertical chain, and in particular at the first level of foreign shareholding, that purpose is fulfilled. The purpose is not served by allowing other entities in the vertical chain controlled by the same shareholder to seek protection for the same harm inflicted on the investment. Quite to the contrary. And for those that are concerned that this might depend on a tribunal's subjective appreciation as to the general purpose of investment treaties, the same basic reasoning could be made by reference to the specific object and purpose of the specific investment treaty that the tribunal is mandated to interpret and apply. On either route, the abuse is to be found in the initiation of multiple proceedings to recover for the same economic harm, entailing the exercise of rights for purposes that are alien to those for which these rights were established. A second but consistent answer is to be found in Ampal, where it was held that it was an abusive process for what was in substance the same claim to be pursued on the merits before two investment treaty tribunals. Reference was made to RSM and Granada and the Apotex Holdings case, both of which accepted that two entities within the same corporate chain were in privity of interest. Moreover, in Apotex, it was not open to the shareholder to rely on an intermediate company to establish ownership of the protected investment, whilst at the same time seeking to distance itself from that company when it came to a res judicata. And what these two cases are doing, and what Ampal is also doing, is recognizing the unique jurisdictional and substantive protections that, quite specifically, the investment treaty accords to different legal entities within the same corporate chain, and approaching the issues of identity and abuse with those unique features in mind. Ultimately, what the tribunal in Ampal did was to offer the shareholder a choice to pursue its claim or that of the intermediate company, but not both. And that is an apt demonstration of why one has to be a little wary of words like banned. The issues on abusive process concern admissibility, not jurisdiction, and there may be many appropriate means to address the impermissible. And in this respect, one notes how UNCITRAL Working Group 3, in its current focus on multiple proceedings, appears to be looking at developing what one delegate called a detailed toolbox. And within that toolbox, the working group is looking at tools such as orders to stay or suspend and the benefits of consolidation, as well as the possibilities for model treaty clauses, including waivers and the like. While some states have or will wish to put into treaty form how to regulate overlapping claims, such as at Article 8.24 of CETA, I note from the working group's report that while there was a general support for elaborating on the notion of abuse of process or of claim, including the notion of double recovery in ISDS, it was cautioned that a certain level of flexibility should be provided to ISDS tribunals in applying that notion to achieve effective control over multiple proceedings. Will such elaboration be useful? No doubt. But the point for now is that the concept of abusive process and its potential applicability in the context of parallel proceedings has become firmly established and already allows for a certain level of flexibility, as aptly deployed in Ampal in putting the claimant to an election. And to conclude, the real message from Heraclitus is not, of course, that strict identity is always legally significant, but rather that time, and with it legal thinking and understanding of how concepts such as abuse apply in this very specialized field, is always moving on. A ban, or whatever one might choose to call it, is not only essential, it has already been put in place. Thank you very much.
Thank you, Mr. Wordsworth. Now we are going to hear the defense of the opposite view by Professor Jan Polsen.
Thank you. whenever you ask a yes or no question of a group of people, you're likely not to get unanimous answer. No matter how clear the proposition is. Don't know why that is really. Maybe it's because some people want to be agreeable, and no matter how absurd the proposition is, some of them will say yes because they just inherently want to be agreeable. Or even if it's one that is a hopeless proposition, there are some people who say no because they like to say no and they want to argue about things. So I assume some of you who are listening have voted wrong already, and you need to understand that there is no way this proposition can possibly be answered in the affirmative. Consider the wording. Parallel proceedings in investment arbitration are abusive and should be banned. One problem is that the word parallel has no meaningful content, and it certainly doesn't have any inherent pejorative meaning. So it really doesn't get us that far to coin this particular expression. But if you wanted something agreeable that you could say yes to, the proposition could be corrected very significantly so, and we'd say parallel proceedings in investment arbitration are not necessarily abusive and should not be banned unless they are abusive. That would be fine. But we can't fiddle. You have the proposition that you have, and you can't possibly say yes to this one. One initial problem with it, if you're going to say yes, you have to consider the fact that it's parallel proceedings in investment arbitration are abusive. But if they are abusive in investment arbitration, it's because there's something wicked about them, and they must be abusive in all kinds of arbitration. So you have to make good on that one as well, unless you think that non-investment arbitration somehow are inherently tolerant of abuse, and that's fine. And then we're in some particularly sacrosanct ground here. Why can't you possibly say yes to this? How many parallel investment arbitrations are there? How many arbitrations are pending before ICSID? 295. I don't know how many at the PCA or pure ad hoc or the SEC and so forth. I guess they're all parallel. And we're going to ban them because they're parallel. But what meaning is there in this word? That can't be right. And some people, I suppose, would say that'd be a good thing. Most of them should be banned because so many of them involve trying to generate an understanding of the word fair. And we can have unpredictable results. And therefore, we should really only have one case. And one tribunal will decide the meaning of fair. And we'll wait 10 years and find out what that word means. And then others can go ahead and decide very quickly because they'll have a handy definition of the word fair. It's a bit of a fantasy world. So you might say, this is, Mr. Paulson, this is silly. Surely we all know that it must have meant same cases being brought at the same time by the same parties. Well, the proposition doesn't say so, but even if that were true, the same parties may have different claims. And the fact that they're the same parties involved is not conclusive and can't possibly be conclusive. You hear that this would be a good rule because it will militate against double recovery. Why don't we get granular and say cases that run the risk of eventuating in double recovery or involve the same ultimate beneficial owners of the rights that are being assessed should not be allowed? That would be interesting and that would be fine. And we could probably come up with that kind of a formulation. But simply parallel doesn't really work. Mr. Wordsworth was kind enough to mention the book I wrote on abusive right. I'd like to clarify that in that book, you will see I have no problem with the notion of abusive process. That's something different. Abusive process involves an adjudicator's considering whether there is an abuse of the proceedings before him or her. That's an inherent function, it's an inherent matter of the judicial function. To put it a bit provocatively, the judge knows abusive process when he sees it, because the judge is the master of the process. But abuse of right involves an infinite number of rights, and no human being can be a specialist in everything and know it when he sees it and know when there's an abuse. My research on the subject shows that judges, I mean judicial officers of states, don't at all welcome the notion of abuse of right as something which they should apply, because it's too open-ended and they don't know what will happen on appeal, and they fear accusations of arbitrariness. So in specific areas of the law, substantive areas of the law, we want more granular definitions, and we want to know where we stand. Now we have a new animal, parallel. Somehow the word parallel is bad. Why do we need to decide that parallel is abusive? We can, as with respect to other notions, like we don't want double recovery, we don't want people with the ultimate same beneficial interest to pursue several claims at once. We have these means already at our disposal to object to such things. National law has been dealing with this for a long time. Common law knows it in various forms of estoppel. The French Court of Cassation has seen the problem, where it's referred to as the rule of the concentration des moyens. If you have arguments in support of a claim, you cannot bring one or two of them and keep a few in reserve and start over again with a second claim. You have to concentrate the moyens, the arguments that you have in a particular case. If you have different claims, you can bring different cases, but not arguments. When you get down into details about how this works out, and the difference, for example, between claimants and respondents who didn't raise an argument which they could have raised and now seeks to raise it on appeal, well, that is not addressed judicata because it wasn't raised at all. That creates its own specific problems. International law, the idea of a general principle of transnational, international law that should be applied in all cases, really doesn't lend itself to resolving these kinds of complicated questions. And so we are left with the idea that parallel in this proposition is something which is abusive, and we know it when we see it, even though some of the cases that arise really don't look as though they have a problem of parallelism at all. Consider the case of two joint venture parties who have created a company in a country, and that company is treated in a particular way which it finds objectionable, and a case is brought against the state. It happens that the two partners have a falling out, and one of them becomes a great friend of the local government and settles its problem, and goes ahead and gets other advantageous deals perhaps, but the problem is resolved with respect to that joint venture partner. We now have the other joint venture partner who is still not getting along with the local government, which gives it no redress, no friendly settlement, and it wants to bring a case. It now brings a case as somebody whose shareholding in that country has been dealt with poorly. That's not a parallel proceeding, that's a sequential proceeding. And what's wrong with it? What is wrong with it? There is no issue of double recovery. And above all, there's no res judicata, there was a settlement. So I fear that by this kind of a generalization, we get into great difficulty, and we put arbitrators in the situation of wondering whether they know it when they see it. And that results in a great difficulty of arbitrary decisions. Thank you.
Thank you. Thanks to both. Both very convincing, of course, but we'll have to make a choice, and the audience will have to make a choice. So we have 10 minutes for our questions, which means no more than 3 minutes for each of us. And it starts with Mariam. Please, your questions, or one question. Sometimes the answer takes the 3 minutes, but let's see.
Thank you, Mr. President. I would like to thank parties for very thought-provoking submissions. I would have one short question to each party. I will start with Mr. Wordsworth. You seem to be very positive in arguing that the principle of abuse of process seems to be very well established already in investor-state dispute settlement. However, there could be only a couple of cases that we could name where tribunals felt empowered to take a strong position on this issue. What do you think is a problem, and what should tribunals do to be able to more effectively approach this issue by using existing legal principles? And you mentioned that tribunals are still interpreting identity test quite strictly with respect to least standards, for instance. And then one question for Mr. Paulson. If I understood correctly, Mr. Paulson, you are not excluding that there could be cases of parallel proceedings which could, in fact, create some harms, and maybe those concerns that have been voiced in international circles with respect to double recovery, conflicting decisions, posing threat to the legitimacy of the system might be correct, but what you are suggesting is that this concept of parallel or multiple proceedings might be very wide and encompass some quite legitimate cases which should not be considered abusive. Could you elaborate more what kind of parallel or multiple proceedings you would consider abusive or problematic? Thank you.
Short answers by both of you.
Well, the answer to the question given asked of me is that there are indeed two recent cases that are showing how abusive process provides the correct answer to cases of parallel proceedings. In terms of tribunals in other cases continuing to apply the triple identity cases over strictly, but I think one has to be rather careful there, because triple identity is applied in multiple different circumstances. And what one sees in cases like RSM and Apotex, in fact, is a very carefully restricted application of the triple identity test, and seeing how it applies in the very specific context of investment treaties. So in actual fact, I think the cases on application of triple identity tests are moving hand in hand with the cases on abusive process.
You? Jan?
I gave, I think, 3 examples, which I can enumerate, and each of them would defeat a particular way of proceeding by claimants in different cases, without talking about parallel proceeding. One is double recovery, so we need to put on our thinking hats and figure out how far that extends and work out in a granular way what that means. No claims by parties that have ultimately the same beneficial interest. And I suppose you could also imagine harassment of a respondent to put political pressure on it and to sort of set the stage for advantageous negotiations. I find that rather unlikely because it's a very expensive thing to do. But I suppose it could happen, and you would and then I wouldn't say this is wrong because it's parallel. I would say that this is an abusive process. And again, abusive process to distinguish that from abusive right is something which I consider that the adjudicator knows when he sees. So when somebody says with respect to discovery application, that is vexatious and oppressive, and the judge agrees or disagrees. Well, the judge knows vexation and oppressive because he is the judge of procedure. But if you're talking about the myriad other fields of substantive rights, abusive right is not helpful.
Thank you. Colleen?
Thank you, Pierre. I will also limit myself to one question for each advocate. Mr. Wordsworth, you talked about the triple identity test and the need for flexibility for that test. And I just was hoping that you could address that a little bit more about what is the content of that test, because without clarity, I think there is a risk that in fact it encourages multiple claimants who may not know whether or not they're the right party or whether the claims might be abusive. Was it 80% shareholding or 100% shareholding or somewhere in the middle? And so it might actually, without the clarity, might invite more claims, in fact, until there is such clarity set. So that was one question for Mr. Wordsworth. And for Mr. Paulson, if you could address, I think an argument that Mr. Wordsworth alluded to and mentioned about the legitimacy on the ISDS system as a whole, and how you see the parallel proceedings moving forward within the confines that you've described, how that interplays with this legitimacy question that we're facing today.
Thank you very much. I mean, in terms of a triple identity test, I want to emphasize that the tribunal has to be looking at the question of what is abusive. It shouldn't be looking at application of strict triple identity tests that derive ultimately from domestic law and domestic legal concepts like lis alibi pendens. Now, the nub of your question is really, well, hang on a sec, supposing there isn't strict identity between claimants and you have different claimants who 80% ownership instead of 100% ownership. And thus one could have the sort of situation where you have the 20% different owner of a joint venture or whatever it might be, not being able to bring its claim. And that would be an incorrect application of the abusive process doctrine. And that, of course, simply requires the tribunal to be focusing precisely on identity of claimants. There's no question that you have to identify a beneficial claimant, a beneficial ownership that is in 100% ownership so far as concerns a particular claim. But what that can mean, as in the Ampal case, is that you're not saying there is a complete overlap in terms of these two potentially parallel claims. In fact, the overlap only applies with respect to 12.5% of the relevant shareholding. So all that is required is a very close focus by the tribunal and what is not in genuinely common ownership.
In terms of consequence on perceptions of legitimacy, as I've said, I have no difficulty with the idea that abusive claims should be resisted. I don't think the notion of this new idea of a buzzword of parallel proceedings, which are just far too indeterminate to be of any use whatsoever. If one invokes the Orascom case as an example, it was a case that was begun and it ended because one of the parties settled. Then you have a second case started by the party that wasn't able to settle. That's sequential. That's not parallel, so it doesn't help at all to refer to it in that sense. What we need to do is to look at it and see whether there was anything abusive about that particular case, and to establish criteria for which that is the case. And there I have no difficulty at all with insisting, and hence my reformulation of the proposition. Parallel proceedings are not necessarily abusive and should not be banned unless they are. I think we all agree that they may be.
Thank you. Lindsay, it seems that I have no time for my questions unless you say differently.
Professor Mayer, perhaps you can ask one question now, and we'll have a little bit less time at the end.
Okay. Then that's a question for Sam Wordsworth. Do you make a distinction between parallel proceedings in a chain of companies and parallel proceedings brought by two joint venturers, each one under a different BIT? In the second situation, do you think there is abuse of process?
No, there's an issue for consolidation, but it's very unlikely that there's an abusive process because the two joint venturers are not pursuing a claim for the same economic harm. And that's what was at issue in cases like Orascom and Ampol. As I understand your question, you have joint venture A pursuing, let's say, 50% of the harm, and joint venture B also pursuing 50% of that harm. In an ideal world, the cases are heard together, but that's not necessary. And it is a potential problem in the system that consolidation is not possible unless the parties agree. But I don't see abuse.
Supposing you said first, well, it's a case for consolidation. Suppose that no consolidation is possible, which may very well happen. So what would you say? Is there abuse or not?
No, there's no abuse because it's a different economic harm, as I see it, that is that the two different joint venturers are seeking to recover.
In spite of the possibility of contradiction between the awards on the same facts.
Correct. That is a contradiction that reflects a defect in the system. And that's why one of the things the working group 3 is looking at is consolidation. But nonetheless, I think it's difficult to say it's an abusive process for two separate joint venturers to wish to bring separate claims.
Thank you. Thank you. I had several questions for Jan, but that will be some other time or some other day. Okay. So now we turn to the rebuttal session. Sam Wordsworth first.
Thank you very much indeed, Mr. President. I mean, one of the key points that Professor Paulson is making is that the term parallel has no meaningful content. And in a sense, one can agree, but that doesn't assist him in his argument, because what I've tried to do in opening is to show how certain forms of parallelism are legally meaningful in this particular context of abuse, and certain are less meaningful because they're unlikely to lead to a situation of abuse. Hence the examples I gave of claims brought separately under contract and treaty where different legal orders are in play. Professor Paulson also said, well, there are means at a tribunal's disposal to ensure that there is no double recovery in a given case. And also there are means available to limit claims to one beneficial owner. That, I think, is certainly true, at least as a matter of the strict legal content, so far as concerns double recovery, because the tribunal will be applying the horse or factory standard, and it can only make the claimant whole and won't permit it to recover twice. So as a useful principle for the tribunal, that is there. But as to an available tool for saying a claim must be limited to one beneficial owner in the same chain, what is that tool? That tool is abusive process. I'm not aware of there being any other reasonably available tool. It's said that international law does not lend itself to resolving these problems. Well, I find that difficult to agree with, because one looks at the International Court of Justice, which we do still all look at as a touchstone in the investment treaty world, and they are spelling out in terms that abusive process is an available tool. And the question is how it applies in this specific context of investment treaties. Some points were being made by reference to the Orascom case, but that's simply a question that's being raised as to the application of the abusive process on the facts of a particular case. Now, the tribunal considered that there was indeed an abusive process because a company owned by the claimant had initially brought a claim, had then divested itself of that claim, selling it to a third party who entered into a settlement agreement, which, according to the tribunal, and one can readily understand that, meant that that claim was settled. When the claimant later brings a new claim, one might say, indeed, it is abusive. But that's a point of detail which has to be left to the tribunal in the individual case to decide. And that's why abusive process is such a useful doctrine, because it gives a framework within which the tribunal can focus on the very specific facts before it and identify abuse, no abuse.
Thank you. Professor Paulson.
Members of the tribunal, with the greatest respect, may I say that you are not entitled to change the question and say that you don't like abusive process and therefore you will vote in favor of the proposition which is put. It is put the way it is put. Now, listening to my friend, Mr. Wordsworth, it comes back to me that he is always the fairest of opponents. He never overstates his arguments, and he never misstates his opponent's arguments. It's marvelous, and it's miraculous that he still seems to win most of his cases. In this case, he has been absolutely fair, and it kills him in this instance in two ways. He has given very thoughtful indications of a number of things that are not second bites, are not abusive, and are actually legitimate parallel claims. Well, I take that on board and note that he therefore is reduced to talking about something which he calls truly parallel claims. Now, those are ones that are bad because they are truly parallel. This really doesn't help us one bit because it's just a way of using some sort of a code to get where you want to go. Once again, we all agree, it seems, that abusive process should not be allowed. That is within the inherent jurisdiction and authority, put it that way, of adjudicators. And what we should spend our time doing is to define in a granular and predictable way what does or does not constitute abuse. Parallel doesn't help.
Thank you. Now we have the poll, the second poll, I think.
That's right. So if I could ask Brandon to please pull up for the audience the poll. It will be the exact same question that you had at the beginning, and you can access that through the Q&A box. So now that you've heard from our debaters, yes or no, parallel proceedings in investment arbitration are abusive and should be banned. And I will let you know as soon as I receive the results from our ASIL team and report back on who has changed the most minds. In the meantime, it may take a moment. So I don't know, Mr. President, would you like to go ahead and start the conversation with the tribunal, and I'll let you know when the poll is ready?
Okay, you mean within our own group or openly?
Openly.
Openly. Yes, of course. Mariam, having heard both speakers, what's your view?
Thank you. In the interest of time, I will limit myself to 3 points. So first, it seems to be a general consensus among the users of the system that certain type of parallel proceedings are raising legitimate concerns and are susceptible to serious harm, not only to a particular case, but also to the legitimacy of the entire system. My second point would be that having heard the submissions of the parties, there could be cases where proceedings brought in parallel are the legitimate exercise of the legal remedies in the hands of the respective parties. So maybe outright ban of the parallel proceedings under very vague concept of parallel or multiple, as they refer to it in Antitrust Working Group 3, or under very wide and vague concepts of abusive would not be right. And maybe more correct approach would be to define what type of proceedings could be abusive and when the tribunals should apply the concept of abusive process. And finally, from today's perspective, it seems that tribunals still do not feel empowered to take strong position against the abusive process. Maybe conservative approach to the interpretation of existing legal concepts and principles doesn't help, like strict application of triple identity test, for instance. So maybe some reform is warranted and some more flexible and evolutionary interpretation of the legal principles from the tribunals are warranted. Thank you very much.
Thank you, Mariam. Kadeen?
So I agree with actually Mariam's first point about there seems to be consensus or agreement that there are certain types of proceedings that would be abusive versus those that would not be, and the common ground from our advocates about common ownership, ultimate beneficial ownership, double recovery as those being sort of parameters to this discussion. I also think that that there's a question of we talked. Mr. Whitworth mentioned the 12.5% in MPAL and sort of the tribunal really honing in to figure out what was overlapping, and then taking note of Mr. Paulson's view that I see it, I see abuse, I know abuse when I see it. And sort of leaving it to the tribunals to make that assessment, as opposed to having a complete bar, seems to be common ground. May be too strong, but I think there is some similarities in the positions. I'm very sympathetic to the notion that we really need to define. We need to define triple identity tests. We need to define what is abusive and get granular, like Mr. also mentioned, because part of it is also in the treaties, the language of the BITs that have opened up that door by allowing indirect shareholders to bring claims. States perhaps should be held to the terms of their treaties, and if not, then we need to either refine those treaties, as Working Group 3 is looking into, and what are the tools that are available to do that, or define with more granularity where are the instances where we would put up a bar because it just extends beyond what was the intent and the purpose of these treaties. And with that, I'll turn it over to you, Pierre.
No, thank you. I don't know, Lindsay, do we have now the poll and I speak afterwards, or I speak now?
How about we give the audience's judgment first, and then you can render the tribunal's decision after. So we have an interesting result here. The first poll, the results were 56% in favor of the motion and 44% opposed. So we had a slight majority in favor. That is switched in our second poll. And we now have a slight majority against, with 45% voting in favor of the motion and 55% voting against. So for this debate, it is the team opposing the motion that has prevailed.
Thank you. Now, I understand the switch, and I think the reason is that, and Jan Paulson is entirely right, and by the way, Sam Wordsworth does not disagree with that, but the question is put in a much too broad fashion, and you have to distinguish between various situations. It seems that we all agree, in fact, on this, and that's why you cannot accept the proposition. You cannot accept it. It's too broad. And also, not only because the situations are different, for instance, joint ventures or chain of ownership are different, but also there may be tools other than abuse of process in some cases. I know personally, and I'm probably not the only one, that Jan Paulson doesn't like the very notion of abuse of rights, and even wrote a book to demonstrate his view. On this last point, I think I personally would disagree, and I think that in some situations there's no other way than having recourse to the notion of abuse of process to avoid double recovery. Well, in the case of a chain of companies, if the company below, the direct investor, is going or maybe going to win, and so the harm will be recovered. Then the mother company should not receive anything. But if you look only, you are the tribunal, and the claim is brought by the mother company, which claims for its whole harm, which may be 100%, by the way, then how can you, on what basis can you tell that claimant there's something wrong, there's a risk that there be double recovery? For instance, I find that abusive. The situation, at least, is abusive. And since you are the master, being the mother company, having control, there is abuse of process. And for instance, because we don't know what is the outcome of the other claim, the claim by the direct investor, the daughter, then I suspend, for instance. I suspend the proceedings to see what happens, because there must not be double recovery, and I don't see any other way to avoid it. Now, that was my view. Now, if I try to make a synthesis of what the three members of the tribunal said, and the simple answer is that we think that the motion should be dismissed. That's it.
Well, that speaks clearly. I think now we have solved all the problems of parallel proceedings and abusive process in investment arbitration, so we can all go celebrate. I'm told to remind everyone, and this is important, the conversation is not over. There is a continuing the conversation link that the audience should have received. And so if you are so inclined, please join after. Thank you very much for joining, and thanks to all the speakers.
So we have no questions from the audience. Or shall we have?
Perhaps after.